Good morning, good afternoon, and good evening to people watching. Today, we're going to present about the recovery of compensation of psychiatric illness in the UK and in Malaysia. A widely recognized psychiatric illness caused by severe feelings of grief or worry is the proper definition of psychiatric illness. When a plaintiff claims compensation for the damages caused by psychiatric disease, the law has always been exceedingly cautious when acting on a basis of psychiatric illness. This has been especially true in cases where the plaintiff has been diagnosed with a mental condition. Psychiatric illness, from the perspective of the law, includes any sort of mental illness such as neurosis or personality change, which is also recognized by medical professionals. This, however, does not apply to the emotional distress, grief, or sorrow in and of itself. Rather, it only applies if this state leads to the physical injury such as hypertension, a heart attack, or a positive psychiatric diagnosis. As I've stated, while assessing whether or not to award compensation for psychiatric disorders, the courts use extreme caution. The reason for this is that it's difficult for the court to determine the monetary worth of the plaintiff's psychiatric injury and whether or not the plaintiff's claims of psychiatric injury are accurate or not. Additionally, it's difficult for the court to determine whether or not the defendant was negligent. In Malaysia, psychiatric illness is considered a recognized type of injury for which a plaintiff is able to bring an action to the court. Despite the fact that there are not a lot of cases submitted to the Malaysian court system in comparison to those submitted in the UK, Malaysia's legal system, when it comes to the case of psychiatric illness, heavily rely on the judicial decision made by the courts of the United Kingdom.
Next, we'll explore the English judicial position on secondary victims. The English legal position on secondary victims is primarily dictated by the case of Alcock v. CC South Yorkshire. When it comes to secondary victims, it is easier to illustrate what is not recoverable rather than what is. Before proceeding, it behooves us to define what a secondary victim is. A secondary victim is someone who witnesses an injury upon a third party by a negligent party, but is neither involved in the incident nor are they injured in any physical way. Secondary victims claim psychiatric injury on the grounds that their witnessing of a negligent party's actions injuring another has brought psychological consequences upon them. In Alcock v. CC South Yorkshire, the appellants had witnessed events on television which were the result of the respondents' admitted negligence. None of the appellants had been injured or subject to any risk of danger, and the majority of them were not even present physically at the site of the event. The House of Lords, applying a test consisting of 3 elements, found that all appellants had no grounds for appeal. It is these 3 elements that are tested in cases of secondary victims claiming psychiatric injury since the case of Alcock v. CC South Yorkshire. The elements illustrated in Alcock v. CC South Yorkshire are that of the relationship of the person to those injured in the event, the proximity of the person to the event itself, and the vector through which the person was exposed to the event. Now, we'll go on to the first element of this test. In establishing the relationship of the person to those injured in the event, it is to ascertain if the psychiatric injury suffered by the plaintiffs is reasonably foreseeable. This typically means the court is looking for an established relationship with the primary victims of the event, such as those of spouses, friends, and family. The only circumstances upon which the plaintiff can share no relation to those injured in the event is if the facts of the event are unusually horrific. The proximity of the person to the event is the second element. The proximity of the person to the event must be fulfilled, both in spatial and temporal terms. According to McLaughlin v. O'Brien, the rule is that affected persons claiming psychiatric injury must be affected by the immediate aftermath of the incident, meaning little must be done to tamper with the state the incident has left its victims in, and that it must happen within a reasonably small time frame. This is contrasted with Alcock v. CC South Yorkshire, where the claimants had only seen the bodies of affected persons some 9 hours after the incident, and the bodies were prepared for formal identification, rather than left in their immediate state following the crash. Lastly is the vector of exposure through which the person was exposed to the event. The 3 elements thus far have adopted a sequential progression, and this applies to the third element as well. It is extremely unlikely that a claimant can fulfill the third element if they fail to fulfill the second. And the same can be said of the second element being unable to fulfill the first, except under very specific conditions. The third element establishes that psychiatric injury caused by events must be by unaided sight and sound, meaning that being told by third parties or watching such events unfold on television do not apply. That said, in Alcock v South Yorkshire, some attempt at leeway was made, but ultimately the courts decided against it as the television broadcast was sanitized enough that any spectators on television will be far enough removed from the incident. As we've seen, rules dictating secondary victims' ability to claim compensation are much easier to define what is not recoverable, as opposed to what is, largely due to the nebulously defined tests established by the English courts. That is not to say it is not well defined, just that it appears easier to work in the negative rather than the affirmative, as it is all subject to the discretion of the courts rather than fulfilling specific undebatable facts.
In regards to primary victims under the English law, these are victims who were mediately or immediately affected in events that resulted in their suffering. These could be victims who were personally involved in the event, witnessed the event as it happened, or witnessed the aftermath. A primary victim can also be classified as a victim who was in the risk of being physically injured, however, not experiencing such affliction. The case of Page and Smith, 1996, demonstrates the recovery of compensation for primary victim where the victim had experienced personal injury, which was psychiatric injury, accompanied by the probability of physical injury. In brief, the plaintiff, who has a mild form of chronic fatigue syndrome, was involved in a minor car accident with the defendant, however, was not physically injured. After a period of time, he felt extremely exhausted and claimed that this was due to the accident and sought to claim damages on the defendant for intensifying his illness. Otten J. listed a series of questions to determine the case, such as whether the plaintiff's illness is true, what symptoms would occur of such illness, what causes the illness, to what extent had the plaintiff suffered with this illness prior to the accident, whether the accident caused or had influenced the condition, whether the plaintiff would still experience the condition in the situation of having no accident, the extent of damages the plaintiff suffered after the accident, and the level of compensation that the plaintiff is entitled to. After further consideration of the case, Otten J. concluded to award the plaintiff these damages for the psychiatric illness of experiencing nervous shock, which had triggered the relapse and chronic intensity of his illness. The negligence of the defendant had significantly contributed to the plaintiff's illness from being mild and sporadic to intensely chronic and permanent. The judge had also rejected the defense made by the defendant and upheld that he must take the plaintiff as he finds him, and that any symptoms that occur to the plaintiff must be taken responsibility of. The ratio of the case had highlighted that primary victims who suffer psychiatric injury do not need the psychiatric injury to be foreseeable, but rather the physical injury needed to be in the range of possibility to be foreseeable, albeit does not have to happen. Although the law can be ambiguous on compensation that is recoverable by a psychiatrically injured victim, Page and Smith, 1996, established the possibility of recovering damages for psychiatric injury experienced by a primary victim.
Under Malaysian law, to claim for recovery of compensation for psychiatric injury, the plaintiff must prove to the court that the said psychiatric injury was as a result of the defendant's negligence and that the injury was a foreseeable consequence of the defendant's actions. For example, if we look at the case of Hasniati binti Hassan and Anwar against Kerajaan Malaysia 2022, the plaintiff sued the defendant for psychiatric injury as a result of their medical negligence. The plaintiff was 27 weeks pregnant at the time in which she experienced abdominal discomfort and vaginal discharge. She was transferred from the initial hospital she complained to, Pantai Hospital, to Penang Hospital, as there were no beds available. It was at Penang Hospital that she underwent C-section birth, and post-operation she experienced severe bleeding and prolonged shock. As for her premature son, he suffered injuries including auto-amputation of his right arm and irregular breathing. The plaintiff developed depression as a result of her son and her own injuries. This example shows that the hospital was negligent in the actions they took to treat her initial abdominal discomfort. It is a breach of duty in the sense that the hospital held a professional duty of care to treat the plaintiff accordingly with correct procedure. The complications and injuries her and her son faced as a result of their negligence is also a foreseeable consequence of the defendant's actions. Had proper protocol and procedure taken place, she would not have suffered from physical injuries and developed depression as a result. The court awarded monetary sums for the physical injuries suffered, whilst for her psychiatric injuries, although she had overcome her depression and was confirmed clear of it, the court held that it would be unreasonable not to award her damages to treat her psychiatric injury in the future, as it was reported to have high likelihood of recurrence nevertheless. On the other hand, an article defendant's negligence causing nervous shock or psychiatric injury to plaintiff Claimant, a critical appraisal by Muhammad Akram, Shair Muhammad, and Farheen by Sardar Baig, clarifies psychiatric injury as a recognized psychiatric condition capable of resulting from the shock of an incident and recognized as having long-term effects, meaning conditions such as depression, PTSD, and so on would be required to make a valid claim for psychiatric injury. This means that the courts would be reluctant to allow a claim for grief and sorrow or distress or fright, fear, or mental anguish, as these are considered to be natural and common feelings that will come or be suffered from at some point in everyone's life. If we look at the case of Jubil bin Muhammad Taib Dara against Sunway Lagoon in 2001, a case in which the plaintiff, who was the husband of the deceased, who fell out of the runaway train ride at Sunway Lagoon, was claiming for loss of dependency as her financial contribution would no longer support their children. The court held that her financial contribution for the children be covered as well as her funeral expenses. However, the plaintiff, who was sat next to the deceased during the ride and witnessed her fall, was observed by psychiatric specialists who concluded that he was not suffering from any psychological disorders as a result. Thus, unfortunately, claims for psychiatric injury could not be fulfilled in this case. Overall, under Malaysian law, recovery of compensation for psychiatric injury is definitely an arduous procedure. The claimant must suffer from a psychological condition in order to receive compensation. This means, unfortunately, even those with heavy suffering, although as a result of another's negligence, it would be difficult for the court to award them compensation for this unless they are diagnosed with a mental illness consequently.
So now moving on to categories of victims, either it be rescuers, bystanders, or involuntary participants. Firstly, rescuers. In English law, generally, there is no duty imposed to go rescue a person in peril. However, if there is a case where one does rescue another individual and suffers psychiatric harm, can they be able to claim recovery from defendant who negligently endangered the person being rescued? In the case of Chadwick and British Transport Commission, a train crash happened in December 1957 in Lewisham. Appellant, who is Mr. Chadwick, had rescued victims of the crash at a close proximity for 12 hours. After the event, C suffered psychoneurotic illness that was triggered by the horrifying experience at rescue. C was surrounded by bloody figures, dead bodies, and screams of people in need of help. C did suffer from psychoneurotic symptoms before at the age of 28, but his ordinary life stresses would not likely cause him to relapse. C was hospitalized due to disabling neurosis anxiety and had died shortly in 1962. The judicial decision in this case was held that defendants are held liable for C's psychiatric illness as they admitted that train collision was caused by negligence on their part. It is foreseeable that people would dispatch themselves as rescuers, and defendants owe a duty of care to their well-being. Rescuers need not to be primary victims that are physically harmed in claiming recovery, but are classified as secondary victims who experience a terrifying event that is shocking and susceptible enough to psychological harm. Next, in the stance of bystanders. In the case of mere bystanders, these people are those who are not in the zone of physical danger, and the question of nervous shock victims resulted from an accident. Will they be able to claim recovery? Looking at the case of Hay or Borhill and Young, 1942, a motorcyclist collided with another vehicle at a tram station, fell on his head and died. Plaintiff, who was 45 feet away from the scene of accident, approached and saw blood. Plaintiff claims that the accident caused her severe nervous shock and seeks compensation. The court questioned the foreseeability of participant in suffering psychiatric illness and the defendant's duty of care owed to the plaintiff. And the judicial decision held for this case was that the defendant was not held liable or did not owe a duty of care to plaintiff. The motorcyclist only had a duty to drive reasonably, and it was not foreseeable in avoiding the cause of psychiatric harm to plaintiff, who is peculiarly susceptible as they are nervous or have emotional disposition. Furthermore, the plaintiff did not succeed in claiming recovery, as the judge pointed out that she was not within the area of potential danger and was merely stumbling upon the scene and had a severe shock to a dead motorcyclist she had no ties with. Lastly, an involuntary participant. Similarly, an involuntary participant who is caught up in accidents. Will they be able to claim for recovery? This is all measured in the degree of foreseeability for psychiatric illness, remoteness, and duty of care owed by defendant to appellant. In the case of McFarlane and E.E. Caledonia, 1994, an oil rig named the Piper Alpha situated in the North Sea had exploded. The accident had caused the loss of 164 men and seriously injured workers. The appellant, who was in a vessel boat named Tharos, stood 550 meters away from the Piper Alpha, witnessed the horrific tragedy. This caused the plaintiff to suffer from psychological harm. Plaintiff had 2 depressive episodes in the past before the tragic event, and the court believed that plaintiff most likely be susceptible to psychiatric illness than the average person. Lord Keith had commented on this case by mentioning that the case of a bystander unconnected with the victims of an accident is difficult. Psychiatric injury to him would not ordinarily be within the range of reasonable foreseeability, but could not be entirely excluded from it if the circumstances of a catastrophe occurring very close to him were particularly horrific. In conclusion, the jury also held that it was plainly foreseeable that a man of reasonable fortitude may suffer psychiatric injury if exposed to shock, being put in fear of his life. However, the judicial decision held that the defendant did not owe a duty of care to plaintiff. The proximity and the degree of reasonable foreseeability in suffering psychiatric illness by plaintiff could not hold defendant liable, as plaintiff was not in the potential area of danger or was in danger due to being a rescuer. Plaintiff was simply a victim who witnessed the explosion from Theros, which was 550 meters away.
Due to lack of lawful action when it comes to actionable tort in regards of psychiatric illnesses, it is hard to discuss the categories of victims involved under this topic, especially in the Malaysian jurisdiction. But overall, there are three categories of victims, being rescuers, bystanders, and bystanders who are participants. So as mentioned before by Naili, rescuers are people who are volunteers who take part in the rescue operation as an aftermath cleanup to a traumatic event. This can be to clean up the site, take care of bodies, or to recover victims who are still alive that are lost in the traumatic events. Professionals who are involved would be exempt from such categorization because it is expected of their job scope to be able to handle emotional tolls. This would include police officers, medical professionals such as doctors, nurses, EMTs, etc., firefighters, Red Cross employees, or others. Mere bystanders, on the other hand, are victims who witness the event or its horrific aftermath and suffer emotional consequences, not by choice, but by chances. So, though it is hard to prove a case as a mere bystander, with the right evidence, the victim should be reasonably compensated because of the unforeseen possibility. Things that need to be evidential within cases like this are foreseeability, proximity, and proving duty of care. Lastly, participating bystanders can be compensated if they are within the vicinity of physical danger. If it were the case that the bystander is in imminent physical danger but did not suffer any physical damages, he is able to be compensated for such shock. So a Malaysian case that I would like to mention is Taruvani Mali, Allegari Sami Pillai against Diner Club. So the case talks about the plaintiff's wife receiving a letter to find that there are condolences sent to her for her husband. She instantly called her husband at work and was shocked, but was relieved when he picked up the call, safe and sound. So the plaintiff then raised a civil suit against the sender of the letter, Diners Club Credit Club. An employee falsely made a change in the system that stated the plaintiff as a dead man. So the plaintiff sued on the ground that the news was damaging psychologically to not only his wife, his child, but also himself. The letter was said to cause, and I quote, shock, fear, and mental anguish. The judges held that the plaintiff had no ground to prove nor sensibly was affected by the emotional toll that the letter caused. On grounds that the plaintiff is a doctor, this measly letter would not do as much damage as he alleged it to. To reiterate the point above, a medical professional would have much more exposure towards a shocking and traumatic event. Therefore, it would be harder for them to be compensated in regards of psychiatric injury. When pleaded, there was no mention or evidence to the extent of psychiatric injury. Even though there might have been anger and confusion, these emotions are not an quote-unquote actionable tort that could be compensated by damages. The difference between psychiatric injury and emotional expenses are fine for a common man, but stark under the law. For an impact on a person to be compensation worthy, it has to be to a certain level. Something that is defined as psychiatric injury has to be provable under a psychiatrist's professional diagnosis. Another case worth mentioning is the case of Dato' Tiru Muthri Nedesan against Maxis Mobile Services. The defendant, Maxis Mobile Services, had registered the number of the plaintiff to a third party, which in turn resulted in him receiving 4 threatening messages. The harassment caused kejutan, kemurungan, tekanan, dan paranoid, which translate to shock, depression, stress, and paranoia. The court held that the mental suffering that was involved posed on the plaintiff was not an actionable tort, this being because the anguish are not admissible in court. This case referenced the case above, in essence, that the emotions experienced are not detrimental enough for compensation to be deemed. There is understandable fear that was inflicted, but for it to be considered psychiatric injury, it has to be psychological damage that affects the victim's other aspects of living and would be long-lasting consequences. In these cases, results are more often than not merely distressing. This would be related to the judgment of Jansche against Coffey, where Brennan J. says, a psychiatric illness induced by mere knowledge of a distressing fact is not compensable. Perception by the plaintiff of distressing phenomenon is essential. Although in both cases, the cause of action was shock, there is no definitive injuries caused to the victims. There's a vast difference when it comes to a normal perception of mental distress and psychiatric injuries under the eye of law.
Both the English and Malaysian stance on recovering compensation for psychiatric disorders are extremely comparable to one another. This is due to Malaysia having a lower overall incident rate of cases. In the majority of cases involving psychiatric illness, the decisions of the court in the United Kingdom serve as a basis for judicial reasoning in Malaysian courts. According to the English position for primary victims, the plaintiff must have foreseeable physical harm in order to be eligible for compensation for psychiatric illness. When it comes to secondary victims, the ACOG test is used to determine whether or not the plaintiff is entitled to compensation. The elements of ACOG test are the relationship of a person being tested to the people who are hurt as a result of the event, the person's proximity to the incident itself, and the means by which the person was exposed to the event are the components that make up the ACOG test. In order to qualify for compensation, each of the distinct categories of secondary victims must first satisfy a set of predetermined criteria that are set by the ACOG test. However, the viewpoint taken by Malaysian is surprisingly identical to one taken by the English law system. When it comes to the primary victims, the English perspective and the Malaysian position is a bit different from one another. The Malaysian position continues to hold that there must be some kind of physical damage suffered in order to maximize the likelihood of receiving compensation. In conclusion, the position taken by Malaysia and the United Kingdom with regard to recovery of compensation are comparable to one another. Despite the fact that there are some distinctions, the Malaysian court nevertheless takes into consideration the rulings handed down by the UK court. Thank you for listening to our presentation.